Thank you so very much for coming. My name is Alan Rosenstein. I'm an associate professor of law here at the University of Minnesota, and I'm one of the co-organizers of today's event. Section 3, Insurrection and the 2024 election. Does the 14th Amendment bar Donald Trump from the presidency? We're going to start this morning with some opening remarks from our interim dean, Bill McGovern, who's the Gray, Plant, Moody, and Bennett Professor of Law. Thank you, Dean McGovern.
Good morning, everyone. As Alan said, my name is Bill McGovern. I'm the interim dean, and on behalf of our faculty, our staff, and our students, I'm delighted to welcome you to the University of Minnesota Law School and today's really important discussions about Section 3. And I also extend a warm welcome to everybody joining us on the live stream. This event will be broadcast. It was less than 6 weeks ago that I got an email from Associate Professor Alan Rosenstein, and he wanted to know, had I absorbed the fact that the Minnesota Supreme Court would be in the national spotlight very soon when it considered the Groh versus Simon litigation challenging Donald Trump's ballot eligibility? My honest answer was, sort of. I'm a bit of a political junkie, and I'm a lot of a law nerd, like many people here. So of course I knew that the issue was out there. I had heard about Michael Pawson and Will Baugh's law review article. I mean, what law professor does not notice when legal scholarship actually makes news? But had I fully comprehended that Minnesota was going to be on the very early cutting edge of a momentous legal and political issue that might be on an express train to the US Supreme Court? No, to be honest, I wasn't. Alan was. And his response was exactly what we want from our energetic faculty. It was, hey, let's sweep out the barn and put on a show. So now here we are. We're all indebted to Professor Rosenstein for turning that crazy mid-September idea into the full-blown national conference we have here in record time. As many of you know, since Alan joined Minnesota Law in 2017, he has built quite a reputation as a highly engaged scholar, a teacher, and most importantly for today, a tireless convener of high-level discussions about policy, law, and scholarship, sometimes on Zoom, sometimes in the flesh. Alan is a senior editor at Lawfare, a term member of the Council of Foreign Relations, and a member of the Scholars Strategy Network. Before he came to the law school, he was at the Justice Department focusing on cybersecurity and foreign intelligence matters. We are so fortunate to have him here in our intellectual community. And thank you so much, Alan, for your energy and your work in building today's event. I'm also grateful to our entire communications and events team for stepping up on such short notice to help us be nimble. That's a good dean word, right? Nimble. And respond to events in the world. So Monica, Olivia, Julie, Riley, Jeff, and Randy, thank you. We are all grateful for all of your help. Because folks, without them, you don't eat. Okay, so Alan also lined up a great group of co-sponsors for this event, and I want to recognize each of them for their support and participation. The Center for the Study of Politics and Governance at the Hubert H. Humphrey School of Public Affairs, along with its director, Professor Larry Jacobs, the American Constitution Society, the Federalist Society, and the law school's Horatio Ellsworth Keller Distinguished Visitor Program. Some of you are Horatio Ellsworth Keller Distinguished Visitors today, so that's great. And finally, I want to thank each and every one of today's participants for your exploration of this crucial and fiendishly complex issue. Until very recently, there's been so little development of serious analysis about Section 3, and there are so many nuances to consider. The issues do not break down easily into the red and blue teams that so often shout at one another on cable news programs. There are unusual bedfellows in this room, as well as earnest uncertainty. That makes for a perfect topic for a conference like this one, taking place at a land-grant public university at the center of our state. Minnesota law prides itself on that, on thoughtful, respectful, fruitful, purposeful discourse. We are delighted to lend that spirit of true dialogue to the proceedings here today. So please leave the talking points behind. I hope you instead bring an open mind and some big ideas. Because you participants in this conference are striving to answer questions fundamental to the future of our American democracy. I can think of few things more important or more patriotic than the work you will all do here today. You may be convening in an ivory tower, or more accurately, in a brick basement. But with this topic, the ramifications of your thinking can have a direct and profound effect on our nation. So thank you all for doing that hard work and for being here, and I wish you all a stimulating and productive day ahead.
Thank you very much, Dean McGovern. The 14th Amendment was adopted on July 9th, 1868, as one of the Reconstruction Amendments enacted near the end and immediately after the Civil War. Today, it is chiefly known for its Equal Protection Clause, but a key impetus for its adoption was the problem of former Confederate states sending what were called unrepentant Confederates back to Congress. One example is Alexander Stephens, who had been the vice president of the Confederacy and was one of the first senators elected from Georgia after the Civil War. Section 3 was written, in part at least, to solve this problem. We'll have the text on the screen for the duration of the conference, with the text that is particularly relevant today highlighted in bold. Section 3 provides, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof," at which point mercifully follows a period. I'm not sure bullets had been invented yet, bullet points at least. But Congress may, by a vote of 2/3 of each house, remove such disability. Soon after the attack on the Capitol on January 6, 2021, and in light of former President Donald Trump's attempt to overturn the 2020 election, including inflammatory public remarks he made on the day of the Capitol riot, discussion turned to whether Section 3 might bar Trump from re-election. This debate quickly spilled beyond the confines of the legal academy. As of now, there are nearly 24 states in which litigation is ongoing to bar Trump from the ballot, and that number is only expected to grow. As we speak, a Colorado district court right now is beginning a week-long bench trial to determine whether Section 3 disqualifies Trump. And this Thursday, the Minnesota Supreme Court, which has original jurisdiction over this issue in Minnesota, will hear arguments in the case of Groh v. Simon, in which petitioners have sued the Minnesota Secretary of State to remove Trump from the ballot. Minnesota may well be the first state to issue a conclusive determination as to Trump's eligibility, and therefore Minnesota may be the case that triggers review by the United States Supreme Court. I'm exceptionally grateful to our expert guests today, many of whom have traveled on short notice from across the country to discuss the historical, legal, and policy issues that the Section 3 case against Donald Trump presents. And I'm very grateful to all of you in the audience here and on the live stream for your interest in this issue. As Dean McGovern noted, this is a question not only of profound importance for the future of American democracy, but also of our ability as a society to discuss the most consequential issues in a spirit of openness, humility, and mutual understanding. I am truly delighted by the diverse views that will be represented here today, views that cut across ideological or partisan affiliations. And as a professor here at the University of Minnesota Law School, I am especially grateful that our chapters of both the Federalist Society and the American Constitution Society have come together to co-sponsor this event, along with the Center for the Study of Politics and Governance at the Hubert H. Humphrey School of Public Affairs. A few logistical points before we begin. We will start today with a panel on the history of Section 3, followed by one addressing the legal issues that a Section 3 disqualification would present, both in and of itself and for election law more broadly. Our lunchtime event will be a one-on-one in which I have the privilege of interviewing Professor Mike Paulson, co-author of the recent Law Review article on Section 3 that attracted global coverage when it was released in August of this year. And our final session will address the broader political implications of a disqualification or lack thereof under Section 3. Between each session, we'll have a 15-minute break, but please do try to return to your seats promptly, as we will do our best to stay on time. At the conclusion of each session, we will save time for audience Q&A. A microphone will be located in the middle here of the room, so please make a line to ask your question. If you would rather not walk, we also have a handheld mic, so you can also raise your hand and we'll get a mic to you. We'll get through as many questions as we can. So with that, I'd like to invite the members of panel 1 to come down, and once they've done so, when we've set up the Zoom for our 4th panelist, I will do a quick set of introductions. Do my introduction here. So with that, I'd like to introduce panel 1 on the history of Section 3. Our moderator today is Professor Kristen Hickman, the McKnight Presidential Professor of Law at the University of Minnesota Law School. And our panelists are Mark Graber, the University System of Maryland Regents Professor, the University of Maryland Francis King Carey School of Law. Kurt Lash, the E. Claiborne Robbins Distinguished Chair in Law at the University of Richmond School of Law. And joining us on the screen is Josh Blackman, Professor of Law and Centennial Chair of Constitutional Law at the South Texas College of Law in Houston. Professor Hickman, please take it away.
Thanks so much, Alan, and thank you everybody for being here. I think we're in for an exciting day. So our first panel today, as Alan suggested, is going to focus on the history of Section 3 of the 14th Amendment and what that history tells us about the amendment's meaning. Of course, a majority of the justices of the Supreme Court today are either avowed originalists or at least sympathetic to originalist reasoning, which makes the history of Section 3 particularly relevant, I think, to understanding how the U.S. Supreme Court at least might interpret its meaning. But given the relative lack of judicial and scholarly consideration of the meaning of Section 3, at least until very recently, even members of the Supreme Court who aren't in any sense originalists may find the provision's history especially relevant in considering its meaning, should they be called upon to consider it. So we're fortunate today to be joined by 3 outstanding scholars who have spent significant time studying that history: Kurt Lash, Mark Graber, and Josh Blackman. Mark, in particular, has the distinction of being someone who started focusing on the meaning of Section 3 of the 14th Amendment long before the recent events that gave rise to this conference took place. So, to set the stage, Section 3 of the 14th Amendment, as you can see up on the screen, provides in pertinent part that no person shall hold any office under the United States who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection against the same. At least in theory, this language raises a whole host of different questions, some of which I think may be harder to answer than others. First, is the presidency an office under the United States? Other language in Section 3 makes clear that senators and representatives are officers under the United States, as are electors of the president and vice president. And then there's catch-all language allowing for others, but no clear mention of the president as an officer. Second, and relatedly, is the president an officer of the United States? The Appointments Clause of Article 2, Section 2 of the Constitution provides mechanisms by which the president may appoint other officers of the United States, but is the president himself such an officer? Third, what counts as an insurrection for purposes of Section 3 of the 14th Amendment? Obviously, given the amendment's origins in the aftermath of the Civil War, that conflict was considered an insurrection. But was the provision intended to apply to other subsequent events? And were the events of January 6, 2021 an insurrection for this purpose? And if we assume for the sake of argument that the events of January 6th were an insurrection, then what behavior counts as being engaged in that insurrection? And more specifically, did President Trump's actions on that day satisfy that standard? Finally, who enforces the terms of Section 3 of the 14th Amendment? Is the amendment self-executing, or does it require enabling legislation? We're going to take these panels in turn, with each of our scholars weighing in on all of these questions. But rather than the standard format of each scholar taking 15 to 20 minutes to lay out the full scope of their theory, we thought it might be easier to follow and a little bit more fun to break things up a little bit. So we're going to go piecemeal podcast style. I think it's going to be a rock'em sock'em panel, and we're going to have a good time. So with that, Josh, I know you were particularly eager to start the discussion of whether the president is an officer under and an officer of the United States. So why don't you lead us off in that discussion?
Sure. Thank you so much to Alan, to Kristen. I apologize I'm not there in person. I teach on Mondays. There was no way for me to be in Minneapolis today. So the starting point is the text, and I suppose it's fitting that there's a very little Josh square and a very big text behind it. Really, the text is what's important here, and not what I have to say in particular. Section 3 has a lot of words, and I think Alan said mercifully there was a period at the end of it. But I want to walk through the text with you one clause at a time. The very first clause begins, no person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state. Okay, what's that doing? This is spelling out who will be disqualified if there's an insurrection that's been engaged in. You can't be a senator or representative. You can't be an elector. You can't hold any office under the state. And you can't hold any office, civil, military, under the United States. So question number one is, does the president fit within that language, civil office under the United States? Keeping track, under. Okay. The text continues. Having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state to support the Constitution. What does this mean? If you took an oath to support the Constitution in one of these key roles, you are going to be subject to Section 3. So it's almost backwards. The disqualification element comes first, then the oath element comes second. Who does it apply to? Members of Congress? Check. Members of state legislatures? Check. Executive or judicial officer of the United States? Check. And then there's this phrase, officer of the United States. Does this language include the president? Right? So let me take a step back. My colleague Seth Barrett-Tillman and I have been writing this topic for about a decade now. And we've long taken the position that when the Constitution refers to an officer of the United States, office under the United States, that refers to appointed positions, not elected positions. In the Constitution, we have something called the Appointments Clause, which I'm sure Chris knows a lot about. It says that the president shall appoint the officer of the United States. This suggests the president himself is not an officer of the United States. You have the Commissions Clause. It says the president shall commission the officer of the United States. The president doesn't commission himself or successors. We have the Impeachment Clause, which lists that the president can be impeached and the officers of the United States, meaning the president himself is not one of those officers. There's a lot of textual clues that the president's an officer in the Constitution of 1788. The question becomes, is there some sort of linguistic drift that by the time you get to the 14th Amendment, did the meaning of officer of the United States change? And we argue that there is not. The second element is the president office under the United States, which Kurt will talk about perhaps a bit more, is conceivably a bit more tricky because we think there may have been the possibility of linguistic drift. So by the time you get to the 1860s, we think some people would have understood that phrase to embrace the elected presidency. So we don't actually take a position on that one. But in our view, because Trump only took one oath as president, and that oath was not as an officer of the United States, he is not subject to Section 3. So this amazing debate and panel which we have here has no bearing because this doesn't touch the guy. I know Mark will disagree with me, and maybe Kurt can talk about a little bit more. But that's the position in a nutshell.
So thanks so much, Josh. Mark, I know from you reading your work that you do view the historical evidence a little bit differently. So let me turn this over to you, and so you can tell us why.
Okay, well, first, I'm in a great debate with our panel moderator and our leader. This is primarily a law panel. I'm the only historian. On that, in one way you can tell is our subject is allegedly the original meaning. If we look at historical works, in my work, I don't talk about original meaning. I don't think original meaning as a concept makes sense. Most historians agree with me. Most lawyers disagree with me. And the result being, I find much originalism of little use when I do history and I'm looking at various articles. Originalists find my history of little use. So here's just a little history. It's not original meaning, it's what Republicans thought. Republicans in the Congress that framed Section 3 routinely used officer of the United States and officer under the United States to refer to the President of the United States. No one has discovered a single use by a Republican that said the President was not an officer of the United States, not an officer under the United States. There was a committee report on another matter issued about a month after the 14th Amendment was sent to the states, in which the committee report said that unless the technical meaning is clearly understood, officer, officer of the United States, officer under the United States are interchangeable, and they refer to everybody in the Megillah. That report was written by Samuel Schellenberger, a leading Republican lawyer in Congress, and approved by a vote of 96-4. Again, with respect to the oath, members of Congress routinely referred to the presidential oath as an oath to support the Constitution. There is no one who disagreed, who said it's not an oath. Finally, when describing Section 3, members of Congress routinely interchanged officer, officer of the United States, officer under the United States. They routinely simply spoke of oaths. No one disagreed. Now, if you ask me in my very limited capacity as law professor, is it possible the text of the 14th Amendment does not communicate what they thought? Well, using some contemporary understandings, maybe, maybe not. On the other hand, we should understand first that if we think it's not communicating what we thought, this is a 21st century canon of legal understanding, not something that was a 19th century canon of legal understanding. Second, if we think we're bound by original meanings that have nothing to do what people are thinking, we can't use a theory of consent to justify originalism, because that's not what they thought they were consenting to. This is the history, at least of the 39th Congress and of the times afterwards. What we make of it as lawyers is a 21st century decision.
Kurt, I have no doubt you're going to disagree with that. But additionally, in your work surveying the historical record of the framing and ratification of the Section 3, I know that you concluded that the provision's meaning couldn't be resolved purely on the basis of the historical evidence. Especially given Josh's and Mark's assessments of the history, can you elaborate your thoughts regarding what leads you to that conclusion?
Right. The article that I just I recently posted, the meaning and ambiguity of Section 3 of the 14th Amendment, presents I think it's the first article to present the framing history of Section 3 and the ratification debates. So I kind of went into a deep dive into what the actual commentary was on this particular provision that was drafted in the early months of 1866, and of course you go through the ratification period, ultimately ratified in 1868. And what I concluded was that some things are clear about this particular provision, but a lot of things are not. What is clear is that this section, and remember, it's part of a very complicated 5-section 14th Amendment drafted by the 39th Congress that they're going to use as a condition for the readmission of the southern states. So they had a lot of subjects they were trying to deal with all at the same time. And the particular subject of Section 3 had to do with about 20,000 former leaders of the rebellion who were waiting to come back to Congress and who threatened in their return to public office to disrupt the Reconstruction efforts of Republicans. And so the way Section 3 addressed this potential disruption was by prohibiting these rebel leaders from either returning to their seats in the House or in the Senate, or from disrupting a presidential election through their participation in the Electoral College, and also preventing them from being appointed, perhaps after a pardon by Andrew Johnson, in lower federal and state office. So that was the particular problem that Section 3 addressed. Whether or not Section 3 does anything more is simply not clear from the text, nor is it clear from the ratification history that we've been able to uncover to date. The text does not tell us whether or not the section applies to any future rebellions. The text does not tell us whether or not it applies to candidates seeking to qualify for or to hold the office of the President of the United States. And it does not tell us whether or not enabling legislation would have to first be passed before Section 3 could actually be enforced. And I know that a number of scholars believe that the text actually does address those, that somehow it's clear on its face. When you look at the actual history, it's not clear at all. The drafting history suggests they took different approaches to all of these issues. Some prior drafts expressly targeted the office of the President of the United States, and the final draft does not. Some prior drafts expressly applied to both past and future rebellions, and the final draft does not. And there's nothing in the draft at all that talks about enabling legislation, but it's paired with Section 5. And we have a number of key Republicans who insisted that the text could not be self-executing, but would have to be enforced by way of congressional legislation. So I've laid out this history, and there are arguments on both sides. Some aspects of the history have to do with silence that I think are important. Mark's right that you don't have anyone talking about how the president was not covered by Section 3. It's also true that nobody said he was covered by Section 3 at any time during the ratification debates. There are a lot of historical issues that were simply not resolved. And so therefore, much of this text remains ambiguous.
So I'm curious, if the history doesn't resolve the meaning, then where do we go in your mind?
Well, the history does resolve much of the meaning of Section 3. It may not resolve the issue that we have in front of us as to whether or not Donald Trump can be disqualified under Section 3, but it very clearly resolves the meaning of Section 3 to the people who actually adopted it. They had a very serious problem in front of them, having to do, just in the aftermath of a civil war with the deaths of 600,000 Americans, and 20,000 rebel leaders who really could skew the political process when they returned. So I think Section 3 very effectively communicated something that everyone in the United States knew it meant and was applicable at that time. In terms of what we should do today in extending it beyond anything that anybody thought about back in 1868, well, that's going to become a question of constitutional theory and what you think authorizes judicial intervention in the political process. There are different theories on that, but if the courts do decide to enforce this against Donald Trump, they will be doing so for reasons that are not rooted in the original understanding of the text.
Okay, I feel the need at this point, before we move on to the next set of questions, to ask for responses. And Josh, if you want to weigh in, I've been asked to ask you to speak up a little bit.
Oh, I'm sorry. And again, I thank you for everyone for indulging my Zoom attendance. So I had a good fortune debating Mark Graber last week at Georgetown. I think there's a lot we actually agree on, and I think we disagree on most of his methodology. When we look at a constitutional text, at least modern originalists, we say, what is the meaning that was communicated? It very well be that the framers had a certain intention. As Kurt said, they never said the president was the officer of the United States. Maybe if you asked them, they would have said yes, but they never did. But the relevant question we ask ourselves is, what is the meaning of the words they convey? And if you could zoom out and show me the text again, I'm looking right at Kurt's lovely visage at the moment. The text enumerates lots of positions. They enumerate senators, representatives. They talk about electors, state legislature. They don't mention the president. And we think the reason why they chose this language, you don't know for sure, is that they were modeling off Article 6, right? That's the Oath or Affirmation Clause, which lists positions that take the oath. And I don't have the text in front of me, but if you look at your pocket constitutions, Article 6, you'll see almost the same positions are mentioned in Article 6 that are mentioned in the Oath or Affirmation Clause. The president does not take an Article 6 oath, and we have some good evidence for this. George Washington, our first president, took an oath before any statute was ever enacted. The very first statute enacted created the oath for a number of positions. That was a statute passed by Congress and signed by the president. Article 6 was implemented through legislation. Perhaps a good segue to our later topic. Washington took the oath provided for in the Constitution, and he's not an officer of the United States. Now, Kristen did ask if there's any sort of ambiguity, how do we proceed? Homer Stanberry, a name you may not know, was the Attorney General in 1867. He was Andrew Johnson's Attorney General. Maybe Mark will discount it because he might have been a Democrat, I don't know. But I think he was still the Attorney General at the time. And he explained out, it's two sentences, let me just read them. He says, those who are expressly brought within its operation of Section 3 cannot be saved from its operation. In other words, if you're enumerated by Section 3, you're toast. But where, from the generality of the terms of description or from any other reasons, a reasonable doubt arises. There's a reasonable doubt if a person is covered by Section 3. How to resolve that doubt? That doubt is resolved against the operation of the law. In other words, if we're not sure if someone's covered, presumption is they are not covered, and that's the best way to deal with the ambiguity that I identify. I think Kurt argues for a little more forcefully.
Mark?
I don't think there's any ambiguity. So neither, again, I forgot to mention, many people, when Section 3 was being debated, ratifying, referred to the president as an officer of the United States or an officer under the United States, or referred to Section 3 as covering all officers. No one took the opposite position. Now notice a lot of words in Section 3 in the 14th Amendment that don't get defined in the debate. There's no definition of person. I've read the entire 39th Congress. No one defines person. No one defines military during the debate. So what the normal thing an historian would do, maybe not a lawyer, is, gee, in other debates, what do they say about an officer of the United States? And in other debates, they unanimously, or 96-4, only Democrats, every Republican refers to the president as an officer of the United States and an officer under the United States. The claim to the contrary means they silently, without anyone acknowledging, maybe they whispered, took a different meaning than they had for every other debate for just Section 3, a provision that was designed to neuter the Confederate leadership. They said, gee, we'll neuter everybody, but maybe not presidents. A little peculiar to me, maybe not to others.
Okay, why don't we turn then to our next question. What is an insurrection, and what does it mean to engage in an insurrection? Now, Mark, turning back to you, we all know that the 14th Amendment was adopted with the Civil War in mind, but as I understand it anyway, and I apologize for not having read the whole thing as thoroughly as I perhaps should have, but my understanding is that you argue in your book on Section 3 that the framers of the 14th Amendment did not mean for its language to be limited only to that conflict and its participants.
You should buy the book even though that argument is not there.
Okay, my fault.
I have 2 new grandchildren. College expenses are building up. Okay, first thing, and this is again important, during the actual debates on the 14th Amendment, nobody defines an insurrection. No one defines engage in insurrection. Having read the 39th Congress through, I can't find a definition anywhere there. So what I'm simply going to speak on is what was the definition in courts and in legal treatises of the time. There was a good deal of evidence from the debate over the Second Confiscation Act, 2 and 3 years earlier, that most members of Congress were familiar with these cases and familiar with these treatises. There's some evidence that there's some knowledge in the general public, but if anyone wants to say, did the general public read Joseph's story? I doubt it. Certainly his inheritance doesn't indicate a big royalty check. The definition at the time was an insurrection consists of two or more people resisting any federal law by force or violence for a public purpose. The public purpose is important. If, for example, on January 6th, the motive for breaking in to the Capitol was getting some furniture and selling it on eBay, that is not an insurrection. There are case law holding it. If your motive is private gain, it must be for some public purpose. So you believe the election is illegal. With respect to engaged in an insurrection, Americans, until the end of the Civil War and afterwards, followed Blackstone. Blackstone said in insurrection, there are no accessories. A person who aids and abets a murderer is guilty of aiding and abetting. A person who aids and abets an insurrectionist is guilty of insurrection. So over and over, and these are numerous trial court charges during the Civil War as well, they state, anyone who knowingly engages, assists, incites an insurrection is an insurrectionist, no matter how remote they are from the scene, no matter how minor their part. Now, the crucial question for Trump, I'll add, is one of speech. Here they're clear on 2 points and very fuzzy in the middle, and Trump may be in the middle. This is not a brief to get rid of Trump, it's a brief to explain the law. Incitement is insurrection. Mere words are not. Everybody is clear on that. What's the line between incitement and mere words? Darned if I can figure it out.
Kurt, can you weigh in on this one?
Well, yeah. Briefly, I was going to kind of resist this for a moment because my work primarily focuses on the opening phrases of Section 3. I kind of disagree with some of the bolding. I think that all of those words are equally important and equally complicated and have to be grappled with. But I've spent my time thinking about the role of the Electoral College and the role of enforcing this. But Mark says they didn't define insurrection, and I don't think that's true. And I do appreciate Mark pointing out that he's talking about other debates having to do with discussions of other texts and other legal norms and other cases. When it comes to the discussion of this text, they talked about what insurrection meant all the time, throughout the framing debates and throughout the ratifying debates. Rebellion and insurrection had to do with putting into the field over 1 million Confederate troops who then went about an armed insurrection that killed 600,000 people, 22,000 in a single day at Antietam, who oversaw the starvation and torture of tens of thousands of Union prisoners in Andersonville and Belle Island, and who brought such extraordinary death and misery to the United States that they deserved death, but that this was a merciful and very light response to what they'd done in their rebellion and insurrection. And they talked about this all the time. And throughout the Section 3 discussions, their focus was always on the rebellion that just happened, the death, the shooting of hundreds of surrendering black soldiers at Fort Pillow. That reference is all over the place in the discussions of Section 3 and what they meant by the rebellion and insurrection whose leaders now had to be prevented from returning to public office. So again, I think you do have a clear discussion of what at least they thought counted as rebellion and insurrection, and it was discussed in terms of the catastrophe that had just occurred. Whether or not it would also extend to a riot was not something that they discussed.
Fair enough. Josh, I know your article with Seth parses the text of this aspect of Section 3 quite closely. What are your thoughts regarding the insurrection question?
Sure. Thank you for that from Mark and Kurt. We don't actually answer the question of what insurrection is. Instead, we focus on the verb engage. And whatever engage means is really important. If you didn't engage in it, you don't have an insurrection claim. We think the allegations against Trump, whatever they are, don't rise to the level of engagement. He was nearby, he gave speeches, he had tweets, he did various other things. We don't think that raises the level of an active act of engaging insurrection. And perhaps as some proof of this, we can look to what prosecutors in Washington, D.C. did. No one's been indicted for insurrection. Not Trump, not the Proud Boys, not anybody else. We don't know exactly what insurrection means, but the insurrection statute's a good guess, and no federal prosecutors tried to use it. Now, perhaps that's because it's hard to make a case for insurrection. Maybe it's easier to just charge someone with seditious conspiracy. But that's the point, right? If prosecutors think it's hard to bring a claim in a criminal court for insurrection, then the court better be really, really sure that they can adjudicate an insurrection claim in a civil proceeding, not with witnesses in Washington, but in a proceeding in Minnesota or a proceeding in Denver, which lacks subpoena power over all the relevant parties where we don't have any of the classified information. So even if you get over the hump of saying the president's an officer of the United States, I think there are serious problems with a state Supreme Court or a state trial court deciding in the first instance whether an insurrection occurred in Washington, D.C., and whether Trump engaged in that insurrection. I think that's almost enough to say that this is a road we probably should not go down.
So, Mark, if Kurt doesn't think, or, if Kurt thinks that, you've got insurrection being the the enormity of the Civil War, and we're not sure what else might be included, and Josh is saying, whatever engaged in might mean, it doesn't seem to include what happened on January 6th. Where does that leave us?
Well, first, it's important to understand that, yes, of course, the framers said the Civil War is an example of an insurrection. They never said the Civil War is the only form of insurrection. They said, for example, the whiskey insurrection, which did not involve the overthrow of the government of the United States, did not involve the overthrow of the government of Pennsylvania, was merely an effort to prevent tax collection. They said that was an insurrection, both during the debates and during the ratification debates. People said it applies to future insurrections. Indeed, if we want to be literalist, when Section 3 cases were brought, the plaintiff said, you see that language? Shall have engaged? That refers to future acts. No one, they argued, who participated in the Civil War is subject to Section 3 because of its use of the pluperfect. And one Southern treatise writer, who a number of people quote on this for different purposes, say, yep, that's the right understanding. So if we're going to be literalist, we have to take very seriously the possibility that the text is unclear as to whether people who participated in the Civil War are subject to it. And given the canon, if the text is unclear, no one who participated in the Civil War is subject to Section 3.
Kurt, you wanted to respond.
I think that's a great point. A couple of responses. What Mark just raised, it did come up in a case where the court discussed the fact that if you're just going to look at the text and not interpret it in terms of its historical context, then you're stuck with this future perfect grammatical construction. that would require anyone under it not to be covered unless whatever they do is perfected sometime in the future, and so therefore it wouldn't cover anyone who what they did occurred in the past. That's ridiculous, right? But if that's all you're going to do, if you want to take the position on Section 3, oh, I can see what it says. I don't need to look at the history. I don't need to look at the historical context. It's clear what it says. Well, what it says leads you to a ridiculous place, that it doesn't cover any of the people who actually accomplished rebellion. So this tells you something from the very start. You cannot interpret Section 3 just staring at the text. You have to consider its historical context. Then when you look at that historical context and how the people actually discussed the meaning of Section 3, Mark is right. There were people who indicated that they thought it would apply in the future. There were also people who thought that it wouldn't apply to the future, that it only applied to past events. But of the few people, and again, it rarely came up, but of the few people who said it would apply in the future, you have people like John Hanna, who gave his speech in 1866 while the ratifiers were deciding whether or not to ratify. And according to John Hanna, Section 3 not only applies to the perjured officials who engaged in the recent rebellion, but to all who in time to come may be guilty of a similar crime. And once again, it raises an issue as to what type of crime it is that we're talking about that would lead to the adoption of this specific constitutional amendment. So even if you take the position that it clearly applies to future rebellions, which it doesn't, it was debated at the time, but even if you do, then you're left with whether or not those future events should look like the issue that caused the text to be added to the Constitution in the first place.
Shall we move on to the enforcement question? Or do we have further things to say on this one?
Did you want to respond?
You want to
No,
respond?
no, I was saying, move on.
Move on, okay. Let's
I'll slip in a response. We're very good at slipping in relevant responses.
We have, okay. Let's keep going here and turn to the enforcement of Section 3 and whether it's self-executing or whether it requires congressional action before it can be effectuated. And Kurt, you're going to start us off on this question.
The need for enforcement legislation, whether or not it's self-executing. This came up a variety of times, both with Republicans and Democrats during the framing and ratification. So the text itself doesn't tell us whether or not it's going to require some type of enabling legislation under Section 5. But when the Joint Committee first produced their initial draft of Section 3, Thaddeus Stevens, the House sponsor who introduced the Joint Committee draft, simply expressly said it cannot enforce itself. Of course, it's going to require proper enabling legislation. And then once the final version of Section 3 comes out, Thaddeus Stevens is furious that it's not as radical as the one that he wanted to pass. And so again, he says the only hope is going to be in our passage of enabling legislation to make this effective. During the ratification debates, you have a Democrat in Pennsylvania who engaged in an extended speech talking about, of course, this cannot be applied against any individual unless there's some type of initially created congressional tribunal who will ensure that no one is disqualified until there's actually a judgment by a nonpartisan, by a fair tribunal. And in his speech, he says, all of us here, Republican and Democrat, of course, you're going to agree with me that this cannot execute itself. There's going to have to be some type of legislation. And then Congress, of course, eventually does. Within months after the ratification of the 14th Amendment, Congress begins to discuss how Section 3 is actually going to be operationalized. And Lyman Trumbull, the chair of the Judiciary Committee, announces the reason why we're going forward with enabling legislation is because the text cannot enforce it. It cannot enforce itself. So you have a number of statements during both framing and during ratification that presumed that this was not going to be self-executing, that no one was going to be disqualified without some type of congressionally created tribunal to determine whether or not they were guilty.
Mark?
Here we have to read the footnotes. First, non-footnotes. Members of Congress repeatedly say One purpose for the whole 14th Amendment in putting in the Constitution is so even when Democrats come in and repeal, there is in fact something left. So let's go to the footnotes. Stevens, he says we'll need execution in many of its respects with a version of Section 3 that is not the final version of Section 3. This version of Section 3 disenfranchises all people who provide aid and support to the Confederacy. I'm not getting the words precisely right, but about 1 million people for 4 years. One of the objections to it was precisely it was going to be impossible to implement. So does a statement that says needs enforcement in many respects about a different provision, what does that say about the newer provision that was put in there and precisely because of enforcement difficulties? The sentence after, Stevens says, by the way, it's going to need enforcement. He says the enforcement requires protection for the freedmen. Has nothing to do with Section 3. Everything to do with Section 1. When Lyman Trouble says the Constitution does not enforce itself, yeah, there has to be other enforcement mechanisms, he describes his proposal as a more efficient and speedier way of executing than was going on. What was going on beforehand? Section 3 was being enforced in state courts. It was being enforced by the Union Army. And if you look through the debates on the Enforcement Act, you'll see many Republicans saying federal law can do it better. Exactly what Stevens said, federal law will be more efficient. You will not see a single Republican say, and Section 3 is not self-executing until there is federal law. The Union Army acted unconstitutionally when enforcing Section 3. Southern courts acted unconstitutionally when enforcing Section 3. Republicans don't say that.
So go ahead.
I would love to respond to that. So again, we're getting a little deep into the weeds, but I think it allows us to maybe segue into another disagreement that Mark and I have. What we're discussing right now is whether or not the people understood that when they adopted Section 3 and its disqualifying of certain persons from taking office, whether or not those disqualifications could take place prior to Congress setting up some type of fair tribunal. In other words, exercising its powers to pass enabling legislation. And we do have direct evidence of key framers and people in the ratifying debates expressly stating that there would have to be enabling legislation. Mark is going to talk about things after the framing and ratification. I just want to focus my remarks on framing and ratification. And Mark challenges my claim that Stevens was talking about the need for enabling legislation under Section 3. Stevens did this twice, by the way, and I think this is very important. Stevens says it cannot execute itself. That's a quote, by the way, in terms of the Joint Committee draft. And then when they get to the final draft, and Mark's right, there was more than one draft. When they get to the final draft, Stevens is furious. He doesn't like it. And he says there's no hope for this provision. I see no hope of safety unless in the prescription of proper enabling acts, which shall do justice to the freedmen and enjoin enfranchisement as a condition precedent. Okay. This is an extraordinarily important moment, and it brings in an additional side to this debate. Look at the opening sentences of Section 3. It names the top 3 offices of the federal government expressly. It talks about the Senate, it talks about the House, and it talks about the President of the United States, but by way of the Electoral College. Okay. Then you get this catch-all provision and other offices under the United States and other offices under the states. As I understand what they were trying to do here, and I think it's supported by what Stevens is saying, is that These texts did not attach to the office of the President of the United States. The presidency was going to be protected by the proper structuring of the Electoral College. You're going to prevent the leading rebels, again, from getting into the House and getting into the Senate and disrupting the Electoral College. Stevens did not like that structure. According to Stevens, right, I cannot look at this as an improvement. It opens the elective franchise to such as states choose to admit. In my judgment, it endangers the government of the country, both state and national, and may give the next Congress and president to the reconstructed rebels. With their enlarged basis of representation and exclusion of loyal men of color from the ballot box, I see no hope of safety unless in the prescription of proper enabling acts. This is exactly what his worry was, that by not specifically attaching to the presidency and just going after the Electoral College, it was going to be possible for rebel disruption within the Electoral College. The only way to prevent that is through proper enabling acts. And what is his suggestion about the proper enabling act? Give black voters in the South political power. And that's exactly what they did. Even before the ratification of the 14th Amendment, they passed legislation which refused to accept electoral slates from any state that had not reconstructed or ratified the 14th Amendment. Then in those states that did reconstruct, they required the enfranchisement of black Americans, who then could join into new votes for the creation of new constitutions, new governments, and vote for these new governments. And that led to the creation of the majority black legislature in South Carolina, who then went on to ratify the 14th Amendment. And those states, now with black voters, would now be in charge of the creation of the Electoral College and the votes for president. It absolutely worked. They got a majority Republican governments in the South, and their electoral colleges, their electoral voters, put Ulysses S. Grant over the top in the election of 1868. So yes, he was talking about enfranchising black voters as a way to enable the proper enforcement of Section 3.
I could jump in for a minute.
Let Josh go.
Yeah, go ahead, Josh. You jump in.
So, I mean, when we talk about self-execution, let's be very clear what we're talking about. In all regards, the Constitution is binding on federal officials, right? We have the Supremacy Clause. We have the Oath Clause. State and federal officials are required to abide by the Constitution. In that regard, the Constitution is always self-executing. That's actually not much in dispute. But I think the more profound question is, how do you get this into the courts, right? How do you actually operationalize or enforce Section 3 through litigation? When the government takes an enforcement action against you, for example, it seizes your property or it arrests you or it beats you up or so on, you can then say, hey, wait a minute, you violated the Fourth Amendment. You seized my stuff, right? You violated my free speech rights. When the government goes on offense, you can use the Constitution as a shield against those claims. But there's a different standard when you want to sue the government for violating your rights. So the example here is Section 1983. This is a very famous statute enacted shortly after Reconstruction began that said if a state official violates your rights, you can sue. This is federal enforcement legislation. Now, about 2 years after the 14th Amendment was ratified, Congress enacts a federal statute that enforces Section 3. It involved what's called quo warranto. That's Quo Warranto, quo warranto. And this text meant that a federal prosecutor can actually go to court, federal court, and seek an action to declare a person who's holding office as disqualified. Now, the statute did not have a very long runway. It was only in effect for a couple of years because of an amnesty that was declared. But I think this is some evidence of how the framers understood this to be resolved. Now, let me make this point a little more bluntly. Kurt and Mark have a very big disagreement over whether it's insurrection, who is an officer, and so on. Maybe one of the reasons why Congress should be in charge here is they can create legislation and say, here's what we mean by insurrection, here's what we mean by who's covered by it, and let's actually go ahead and enforce that. No such legislation exists today, and we don't have that input from Congress, which is really in the driver's seat. After the Civil War, the states were not trusted. The states were not trusted. I don't accept the position that Section 3 empowered the states to knock people off the ballot. This would not have been something that was likely understood at the time. But the more important point is we don't have the legislation today. And I know people don't like to say it, but Chief Justice Salmon Chase wrote a decision shortly after the 14th Amendment was ratified. He said, Section 3 requires enforcement legislation. That decision has been cited dozens of times by other courts, was praised in northern and southern newspapers. It hasn't been challenged until fairly recently. I think we should listen to Chief Justice Chase and not have the states sort of do this on their own, absent federal legislation.
To go backwards on Griffin, Griffin, of course, is evidence the other way. Of course, the other judge in Griffin says it is self-executing. I've been going through the newspapers. The newspapers have a very interesting pattern. Democrats praise Griffin. Republican newspapers think it's a horrible decision for reasons I gave. What Griffin says is if Democrats take over, repeal all laws, Section 3 is a nullity. I confess to agreeing with everything Kurt said, except that it has anything to do with Section 3. Kurt is absolutely right. Stevens believed because of weaknesses in Section 3, you needed a law enfranchising African Americans, also weaknesses in Section 2. But at no point did Congress call a law enfranchising African Americans as implementing Section 3. And they knew how to say it because they called other laws implementing Section 3. So if our issue is whether Section 3 is self-implementing or self-executing, the fact that Congress needed to exercise other powers after Section 3 is not evidence one way or another. The only evidence we have is first from framing and ratification, a belief that the entire 14th Amendment was needed in case Democrats took over, so there'd be some vestiges left. And yet, the post-ratification evidence that it was implemented outside of Congress without congressional objection.
So I want to shift gears slightly with respect to all of this and ask, we were talking at dinner last night about how disqualifying President Trump from the presidency under Section 3 would require his challengers to run the table on all of these issues, which, we've heard persuasive arguments for and against a variety of different issues over the last, better part of an hour. I'm curious which of these issues each of you sees as posing the greatest challenge to efforts to disqualify President Trump, and why? Why don't we give Josh the first crack at this one?
Thank you. Let me put it this way. We've argued for years that officer of and office under mean different things. If a court says, no, Blackman, you're wrong, it's the same thing, then those issues are both knocked out. In other words, if you think the president's an officer of, maybe you can distinguish he's not office under, but probably not. In which case you're down to self-execution and whether there's an insurrection. I think the self-execution argument will be, muddled by the state courts, unfortunately. Already a judge in Denver said, oh, we don't have to worry about self-execution because we have a state statute, and our state statute allows us to do this. In fact, there were some cases in the 1860s where states enforced Section 3. Again, if you take the position that state law provides your cause of action, you can get past the self-execution issue. I don't think that's right, because if Chase is correct, then the state statute has no effect on federal officials, it only applies to state officials. So really, again, if you have a judge who sort of walks past the officer issue and whistles past the self-execution issue, then we're left with insurrection. And again, we're going to have judges who are not in Washington, D.C., who do not have access to the classified information, who don't know all the things that happened, they don't have the grand jury records, deciding whether there's insurrection. That's going to be very dangerous. But again, if a judge can leap past the sort of threshold issues, maybe I'm a cynic, this is Mark's political science hat, I suspect the courts will say, yep, this is insurrection. And then we'll have an emergency appeal to the Supreme Court, and my nearest my Christmas vacation will be ruined because I'll have to do all that stuff over the Supreme Court in December. But again, Alan and everyone else in Minnesota, your timing is perfect because I suspect if we have hearings the first week in November, this can get to the Supreme Court, I don't know, by Christmas, right? By mid-December. That's around Bush v. Gore timeline, right? So this can go upstairs very quickly.
Kurt?
Yeah, I agree with that analysis that it could get there very, very quickly. In terms of what the key issue is going to be, you're right. We've talked about this. I know Mark and I have been on other panels discussing this, and it's probably going to come up later on in panels today, that so many things have to fall in the same direction over and over again. It does apply to future rebellions. It does apply to the President of the United States. It does apply not just to holding the office of the President of the United States, but also qualifying for the President of the United States. It also doesn't require enabling legislation, and it also does involve the types of events that happened on January 6th, and it also does involve the things that President Trump did, during January 6th. So all those things all have to fall in the same direction. Any one of them, of course, can end the litigation. So I'm not exactly sure which one will be most important to the court. From my perspective, the most important issue has to be one of originalism. I know that Mark's a critic of originalism, but we do have a court that is very attentive to not intervening unless they believe that they have first received the authority to intervene by the people themselves, and determining whether or not the people themselves have authorized judicial intervention into the political process requires an investigation of history, an investigation of an understanding of what the people did when they wrote the text. So I think the key issue is going to be whether or not courts believe that they can intervene in the absence of conclusive historical evidence.
Mark?
I've spoken in a clear, confident voice, and I want this to be in my most clearest, confident voice you can imagine, because this prediction is nearly certain. The court will not care about anything I say. Please, my fist is banged down. I've had the very difficult burden of not simply persuading you that there are some features about history I'm right, but in fact they are easy. But I've seen lots of things the Supreme Court has done that I've thought, well, this is pretty easy on one way, and they come out the other way. So, what they will do, they'll do what they want to do, and it won't involve what I want them to do or think is accurate. If I had to speak in the way Kurt has spoken, not what I predict they will do, but what I think the most difficult issues are, I think there are two difficult issues. The first, one reason why there are no charges for insurrection is starting in 1894 and accelerating in World War II, federal courts, the Supreme Court, began to narrow the original understanding of insurrection. So if the court are living constitutionalists, which their originalism often is, they may take the more narrow contemporary understanding, which has lots of merits to it, over the Blackstonian understanding, which still prevailed in this time of the Civil War. The second is one I indicated. History can tell you incitement. History can tell you mere words aren't enough. It's a fact question. Where is Trump on that spectrum? I don't like him, so I'm inclined to put him over there, but I know I have friends here who are inclined to think it's over there, and I think reasonable people can disagree, but that's what I think. What John Roberts and Clarence Thomas are going to think, I can't tell you.
Okay, so another question for you all that I'm curious about. So, as we've talked about, until, one of the features of this conference is the fact that the interpretation of Section 3 of the 14th Amendment isn't one that has been debated unendingly for decades. It's Mark's laudable scholarly efforts before the events of January 6th notwithstanding, it's a provision of the Constitution or the 14th Amendment that very few people have focused on until very recently. Exactly. So I'm curious, originalist methodology included or notwithstanding, what do you think the hazards are of plucking this obscure provision out of, from the long ago Civil War that, these days it does seem it's long ago history, it seems like, and applying this provision in the current context? What are the hazards or pitfalls of doing that, do you think? Since you're the originalist, why don't you start?
Well, I should start by saying that the difference between historians and originalists is that historians don't believe that there's any original meaning to the Constitution until they're contacted by the New York Times. At that point, everybody has an opinion. I actually am a big advocate of courts taking seriously obscure provisions and restoring visions that the American people had attempted to write into law, but which were wrongly ignored over time. And so I'm not going to disparage an interest in a long ignored provision simply because it's been long ignored. Some of you, if you follow 14th Amendment debates, you know that many of us believe that the court should take new looks at the Privileges or Immunities Clause. I'm part of a number of scholars who believe the court should take more seriously the Citizenship Clause, not just the National Citizenship Clause, but also the State Citizenship Clause. These are clauses that have not received a lot of judicial attention or a lot of scholarly analysis. And so I'm not going to, it would be unprincipled, it would be hypocritical of me to say they shouldn't look at and consider the possibility of applying Section 3 if they really believe that that was the understood meaning of the people who adopted it. It is something new. It does raise, the difficult questions of, how fast do we want to proceed when the scholarship is just beginning to ramp up. I think that's a serious question, but I have to admit, I've never seen scholarship ramp up so fast. There are other provisions that have been languishing, for decades that have not received the same amount of attention that Section 3 has received in just the past few months. So I think we're doing the best we can, and I wouldn't disparage it just because it's new.
Josh?
If I could jump in. Yeah, thanks, Kristen. It's unfortunate that all this scholarship has arisen in the context of Trump, right? It's impossible to celebrate any of these articles, whether by myself or Michael Stokes-Paulson or Bode or any of the others, from Trump. In fact, we talk about Trump all the time. I think maybe Professor Graber has the claim to have been writing about this beforehand. It became relevant. I think Gerard as well, Mike Leoka. But most of the people talking about this, they're talking about it because of Trump. And you can't separate that.
It's true.
I think one way that scholars can sort of get beyond Trump is to offer a generalized theory of how would this apply behind the veil of ignorance. In a black box, we didn't know about Trump, how would this apply? And I will continue harping on the officer question. Maybe Alan can ask Mike Paulson about this later. They're very quick to say the president's covered by the phrase officer of the United States. What does that phrase mean? Who's covered by it? Do they have some generalized theory of what this language means outside of Trump? My colleague and I, Seth, have been writing about this topic for nearly a decade, before Trump was even, before insurrection was even on our minds. And we can discuss this, and we have discussed it beforehand. But when a theory comes along and says, well, Trump is there, president, officer, whatever, it's all covered, without telling us what else that language means, it's something to be skeptical of. I think more generally, when we're talking about Section 3 and originalism, we need to keep one thing in mind. Every time you disqualify a candidate, you are disenfranchising people. We should just be blunt about that. Whenever you say that Trump, you cannot be on the ballot, that's what the courts can say, you are disenfranchising people. Even worse, let's say they write the guy in and they reject the votes in the back end. you're doubly disenfranchising people. We're not talking here about reading the Constitution that expands individual rights. It's actually one that contracts it. I'm not an election law scholar. Lots of people are. But this is generally the thing that you say is bad, right? The Roberts Court is making it harder to vote, harder to vote. This could be the single largest enfranchisement in American history. This will make Bush v. Gore look like nothing. We're not talking about some Floridians who couldn't punch a Chad in Boca, right? This is not what we're talking about. We're talking about knocking off, frankly, the leading candidate from the ballot and saying that, no, you can't vote who you want to vote for. You want to talk about stop the steal, right? People will look at this as a coup. I don't want to split this too mildly. So you're be damn sure that you're right about what officer of the United States means. You're be damn sure you know what insurrection means to go down this road. Right? This is not some sort of fluffy case that will be in common law casebooks. This is really something serious. And I'm grateful that we have a panel today, an all-day conference, which I'm sorry I can't attend, looking at these issues carefully and hope that the judges in Minnesota, the judges in Colorado and elsewhere, understand what road they're going down here. This is not some sort of idle academic exercise.
Okay, I want to give Mark the opportunity to say something, but before doing that, be thinking we've got a few minutes left after this, and there will be time for people to ask questions, so get your questions in mind. If we've got microphones that are going to be run around, let's get ready for that. And before we do that, let's turn it back to Mark.
3 points, I promise, very, very briefly. Point number 1, you might think the danger of an old provision that hasn't been analyzed, the Supreme Court is likely to get the history wrong. But from my perspective, and I'll use Bruin as the classic example, they get the history wrong on new provisions, old provisions, provisions with a lot of scholarship, provisions with the not. I don't see any correlation. So I'm not worried. A second on desuetude, it strikes me we want to think of 2 different examples. The first is an example of a law that's on the books. People frequently disobey it, and only after 100 years they decide to enforce it. That's really problematic. Another is a law that punishes something that we don't expect to happen. And it doesn't happen for a very long time. So it's not the case Trump can look back and say, gee, other presidents tried to overturn an election result, why aren't they punished? The last is one of the real virtues of this debate is we've just learned that contrary to what a number of us were taught, the United States has an element of militant democracy, that there are limits on democratic processes in the name of democracy. And the theory of militant democracy is sometimes we limit democracy here to get more democracy downstream. So Professor Blackman is absolutely right that in one sense to disenfranchise Trump is to limit democracy in 2024. The question is that I know some people debate whether or not to disenfranchise Trump will mean less democracy, fewer people who will get the right to choose in 2026, 2028, etc.
Okay, audience questions. We have a few minutes. There's a microphone right there. Yes, sir.
Does the panel believe that Article 3 judges are covered by Section 3? And using the whole text canon of interpretation, does the unitalicized phrase, judicial officer of any state, help us to answer that question?
Gentlemen?
Oh, I think that's for me. Sure. So if you look at the text, which I'm grateful is still up there, judges are appointed by the president. They are officers of the United States, and federal judges do hold office under the United States. So yes, they are disqualified. There were some federal judges that actually went to the Confederacy. One of them was actually impeached because he never actually resigned. So I do think federal judges are covered.
Let's savor the moment. Ditto.
Hey, we've got unanimity.
I agree.
Laura?
Yeah. The Constitution makes the president the commander-in-chief. Does that make him a military officer?
I can handle that one.
Sure.
That's a very common argument that we get. The president's a civilian officer. It's always been understood that way. Joseph Story said this. I know Mark was knocking his royalties, but Story understood the president to be a civilian officer. When FDR died, they tried to seek military benefits, and the courts held that no, he's civilian. This is a long-standing interpretation. The president's not a military officer.
I think in the long run, the arguments I'm making don't depend on that. The arguments that Kurt and Josh want to make don't depend on that. That this isn't the tiebreaker. If you think it's a tie, this is not the tiebreaker.
I think that's right. Is that microphone on?
I think so. Is that microphone on?
This
Yeah.
one? It's on, I think.
Yeah, I think I
Yeah.
can hear it.
Go
ahead, Bert.
2 points or questions. Point one, the amendment refers to insurrection or rebellion. Are they simply synonyms, or is there a difference in this context? And second, to Mark's issue of incitement, does Brandenburg at all help to resolve it?
Good questions.
Well, clearly their definition of incitement wasn't Brandenburg. It was substantially less. Again, many of us living constitutionalists have no problem saying it's got to be closer to Brandenburg, but that's not what they thought. Your first question again, just?
Rebellion.
Okay, here, one of the purposes of the language is you see rebellion in many opinions, not all, is an insurrection aimed at overthrowing the government. But I've run through the cases. I've seen about 5 to 6 different definitions of insurrection or rebellion. Insurrection is the general phrase. There's agreement on that. Is rebellion a synonym? Some judges say so. Is rebellion a subset? Some judges say so. What's the precise subset? Judges disagree. So I said there's agreement on, here's the universe. Which part is carved out by rebellion? I see disagreement in the legal literature.
I don't think I disagree with that. This is just additional information. In my article, I present all the different drafts, all the different precursors to Section 3, and some early drafts used the phrase insurrection. Some drafts used rebellion. Some used conspiracy or rebellion. So different. There didn't seem to be a particular agreement. And in fact, and I hope to spend more time to study it, I think their different use of the terms was reflecting different theories about what had just occurred, right? And so they may have had different definitions in their own mind. But when it came to the end of the day, they had to get something drafted, and they had to get a sufficient number of votes to agree to it. And they were in trouble. The Joint Committee had produced a multi-sectioned 14th Amendment with their version of Section 3, and everybody hated it. And it was clear that it was going to be removed. And so the Senate went into a private caucus, and in a few days, apart from any public view, hammered out a different version of Section 3 that presumably was going to get a sufficient number of votes to allow the 14th Amendment to get passed. So my pet theory is that they included both rebellion and insurrection simply to reflect the fact that they knew that different people preferred one term over the other, and everybody knew that they would look at those words as having to do with the rebels who had just, sent 1 million troops into the field. So I think they included those terms just to be as inclusive as possible and get the votes.
Can I briefly address Brandenburg just for a moment?
Sure.
This might be a question for Mike Paulson later. Will and Mike have argued that the 14th Amendment basically repeals the First Amendment, Section 3. In other words, if there's a conflict between the free speech protections of the First Amendment and Section 3, Section 3 prevails. That's a very aggressive reading of constitutional law, and it's not at all clear. Look at Clement Vallandigham, who was a prominent critic of the war, arguing that he was disqualified. He still had his free speech rights, even if he was indicted and charged with some offenses. So I would be very hesitant to say that, oh yeah, we're just going to chuck the First Amendment out, people who engage in it. And if you don't disagree with me, Marjorie Taylor Greene has charged that a member of your congressional delegation from Minnesota engaged in insurrection recently. So be very careful what you wish for.
So as we like to say here at the University of Minnesota, when it comes to workshops, we've got 3 minutes and we've got 3 people in the queue, so shorter questions, shorter answers. Alan, go ahead, please.
Sure. Is failing to call out the militia to suppress an insurrection itself an act of insurrection? And if so, does that weigh in favor of treating the presidency as an office subject to disqualification, since only the president can suppress insurrections or has primary authority for suppressing them?
So Seth and I have written that failing to act is not itself engaging in insurrection. The example there is James Buchanan. History shows that he sort of stood by idly as the Civil War began. He didn't do much, and that was his choice. And I think the failure to act is not itself engaging in insurrection. So failing to call out the militia is a judgment, might be a bad judgment, a political judgment, but it's not itself engaging in insurrection.
You can read Hanway both ways. The short answer is that's one on which history is not 100% silent, but speaks with such a whisper that nobody can really hear. What Hanway was a farmer. There was a riot or insurrection, a fugitive slave escape. He goes to investigate. He's asked to help out, says no. The opinion, the charge says, you can't get him for that because he had no duty to help. Now, one can read that as nobody has a duty to help, or one can read that as saying, well, he had no duty to help, but the President of the United States had a duty. So you can go both ways, but that's why it's a whisper that each of us can hear in light of our own predilections.
Yes, sir.
I believe it's Kurt.
Yes.
Okay. I apologize. As a newly graduate of law school, I feel really bad calling you by your first name. But my question
We're all
is,
friendly. It's Minnesota.
if we were to take your position, doesn't that mean that Article 3 is only effective in Civil War instances or those acts that lead up to Civil War? And then secondly, the last line of the section says, but Congress may, by a vote of 2/3 of each house, remove such disability. Isn't that on its face an enactment? Because otherwise, how does that fit into the section if we were to rely on the states to enact the disability and then the federal government to remove that disability? Is that the way that we're supposed to be looking at it?
Okay, so let's see. So isn't the second one its own form of enabling legislation? Are you saying that it presumes self-execution?
Yes.
Okay, I think it could, and again, okay. Now this relates to your initial question as to whether or not, under my view, it would only be Civil War like things. Again, my position is that it wasn't resolved whether or not it applied outside of the Civil War, and so yeah. So from that point of view, yeah, it only applied to that Civil War and the particular atrocities that were associated with the Civil War. It's ambiguous. If you want to apply it beyond the Civil War, then now it becomes ambiguous as to whether or not it applies to things that are similar to Civil War, the language that Hannah used in his speech, or whether or not they would turn to Blackstone and use insurrection or some other non-Civil War kind of device. I don't think it was resolved. So I think that's ambiguous. And I think that would also be my answer for the last part of your question. I think it is possible to read that language in a way that suggests they would have some type of operational effect on its own, but then Congress would step in and decide whether or not to forgive. However, I think that it doesn't have to be read that way. And we know that key Republicans did not read it that way, that they anticipated that if anyone was going to be disqualified, it would have to be by way of some type of congressionally created enforcement mechanism. And Congress would also have the additional power to forgive, even if someone ultimately fell under that. I don't think that's an absolutely required reading, but I do think that the history suggests that it was in play, and that's part of the problem that I have. I don't think it was resolved one way, one or the other.
So Alan, is it okay if we run into our break? We've got one last question, so please go ahead.
Thank you. I practiced business law for 15 years, so don't get to do a lot of constitutional law, so I apologize if this is a very simple question, but it'll probably be quick then. When doing constitutional analysis or interpretation, are there any sort of, is it approached strictly esoterically as a thought process, or are there considerations of things that are sort of like universally good for the country? So, like if like we could probably all agree that insurrection is bad, or we might be able to agree on is.
Jefferson said a little insurrection is good.
Well, yeah, yeah.
We can't even agree on that.
But if we say go back to 1993 instead of 2023 and have this conversation, and we're just talking like abstractly about these issues, would we start with the premise that, yeah, a president shouldn't have led an insurrection, or do we say, no, these are the exact words that the Constitution says, and this is what they were thinking back then, and we're going to examine it from that perspective?
Do you think it's a great question, and I think you can, everyone else can jump in. Do you think the country has a uniform perspective as to whether or not a president engaged in insurrection?
No.
Okay, so we're dealing, this would be part of my answer.
Yeah, okay.
We're dealing with a situation of, if you move in this direction, half of the country will say, good, that is for the good of the country, and the other half will say, no, that's bad for the country. And if you go in that direction, it flips around. And that goes to what I think is at least my fundamental theory of constitutional law, this esoteric principle that you're talking about, that we have fundamental pluralistic approaches to what is good and what is bad. We have different understandings of facts, and ordinarily we work those out in the political process. And precisely because we have different opinions. The theory of the esoteric theory of the Constitution is that political process should remain due to our disagreements until we reach a point where a supermajority of people all come to the same conclusion, darn it, that's bad. At that point, I think that does lock in, and I think courts do have to enforce that vision of the good. But right now, I think we're divided.
If I could,
I'm sorry, if I could just.
Josh, and then we'll let Mark have the last word.
Sorry, the Zoom crosstalk is not always ideal. I apologize for interrupting. So Mark made a point a moment ago that I've heard a lot that, this might be our last election or something like that. If we elect Trump, then we'll never election ever again. I'm exaggerating slightly. If that thought even creeps into a judge's mind, he should immediately desist and maybe take his robe off, right? This is why we have a political question doctrine. In other words, if a judge's interpretation of Section 3 turns at all based on what a candidate might do once in office, then I think we're past the Rubicon, that is not a question for judges. I endorse what Kurt said. These are difficult questions. Even going back to the Civil War, within a couple of years of the ratification of the 14th Amendment, there was an amnesty. They said, this ain't working, right? We're not going to be in the business of disenfranchising our former citizens, even after an actual civil war and rebellion, that we realized very quickly that this is a very dangerous tool. And that's why the thing's been neutered. It hasn't fallen into destitute because it's obscure. It's because this was maybe not the best idea. There have been many civil wars in England, and how to deal with people after the Civil War, how to bring them back into the fold, how to treat them as treason, as traitors, or let them be back as citizens. These are hard questions. An idea that we can just suddenly say, oh, we got a 200-page law review article. That's it. That settles the matter. I think we can do better than that. And I wrote one of those articles.
Last word to Mark.
I maintain I am clearly right. I maintain that any social scientist or historian familiar with the evidence would acknowledge I am clearly right. I maintain that any civilian interested in the outcome that they think my research follows will say, I am clearly right. I maintain that any person interested in the other outcome will maintain that Kurt and Josh is clearly right. I maintain for this reason, given our debates over history are actually debates over the merits, we should debate the merits and let historians and social scientists do the political development without worrying too much whether it affects Mr. Trump or not.
I want to thank everybody on our panel very much.
Pleasure.